And we're live. Hello, everyone, and welcome to Legal Bites. I'm Alita. I'm a lawyer, and as always on this channel, we explain the law one bite at a time. This week, we are on my channel with the Lawyer Spot. I have with me, of course, the wonderful Uncivil Law and Nate the Lawyer.
Hello. I have my shirt on seriously.
Yes. Awesome.
Yes,
awesome.
Is Kurt, hold on, you hear that? Is that outside Kurt?
That's
Kurt,
outside my
you?
house. Yes, it's
Ooh.
yeah.
What's going on in Austin?
He lives in the hood.
I live two blocks from the police station. It happens.
They're coming for you.
You need legal advice. You need legal advice. You're on the right
I'm not going to go quietly.
So there's a lot going on this week, right? We have, I guess, to begin, we can talk about Epic versus Apple, Epic Games versus Apple. So this is the antitrust case of probably at least the decade. I don't know about the century, but at least the decade. It's what so many people are talking about. It's not really a David versus Goliath story, though. It's kind of like a David, or more like a Goliath versus a smaller Goliath. We have one multi-billion-dollar company going up against a multi-trillion-dollar company alleging antitrust violations. Which of course this case is, if you guys don't know, what happened was Epic Games, the maker of Fortnite, over the summer tried to work around Apple's policies on in-app purchasing, and by providing a way for users to buy what they call V-Bucks. These are currency within the game Fortnite, to buy them directly through the app itself, as opposed to through in-app purchase on Apple. They did the same thing on Google. They were pretty much immediately kicked off of both Play stores. And then pretty much immediately after that, it seems like they totally expected it. They were maybe even hoping for it. They filed lawsuits against both companies in California, in federal court in California, and now we're here at trial. So it's trial week against Apple. So what are your guys' thoughts on this case?
Well, my thoughts. My area of expertise is kind of like the inverse of this, because I deal with patent law, which is creating monopolies, and this antitrust, which is destroying them. But still, there's some relation there from the technology field. So my thought is, I think Apple has the better end of the argument, because Epic, it seems, has not been able to sufficiently distinguish how Apple is different from a legal perspective from, for example, the PlayStation or the Xbox or the Nintendo Wii. So the idea fundamentally is some sort of unlawful tying, undue market pressure, because Apple controls the App Store. They're the only one that has an App Store on their device. They don't allow anyone else to have an App Store. So the idea is, well, that's an unfair tying, unfair competition, because other people should be allowed to run an App Store, which sounds superficially appealing. The problem is there's basically the equivalent of the App Store on game consoles as well as other kinds of devices, but game consoles are the most obvious. If you want to buy a game on Nintendo Wii or Nintendo Switch, you can go online into the Nintendo store and buy the Nintendo game. There's no other store other than the Nintendo store to buy the game from. So Epic's theory doesn't allow them to distinguish. Now, Epic's been trying to argue that they're somehow special cause, but I haven't found it be terribly persuasive as of yet. So I don't think the law supports Epic's position, and I don't see a way to distinguish from other sort of walled gardens like I alluded to.
I don't know. Epic survived the motion to dismiss, which I was like totally shocked about, right? I spit my coffee and I'm like, they're going to trial on this one, right? It makes sense. But I got to give Epic some credit. Their lawyers are masterpieces at surviving the motion to dismiss. I think they've won the trial already, just surviving the motion to dismiss.
Fair.
I'm just telling you. Did you honestly, Kurt, did you think they were going to survive the motion to dismiss?
No, not really.
Of course, yeah. We thought that, so, they're legal geniuses over there. But their argument, giving it the generosity, I think it should be given. Apple has 50% of the cell phone market, right? At what point do you now have a monopoly? Because now because Epic's real argument is that, hey, even though they're still in Google and all this other stuff, their argument is, hey, they got 50% control of the market. If I don't do what they say, my product is now gone from 50% of the market. So their argument to limit the market to Apple and its market share over the smartphone market, I think is technically sound in the sense of, I can't get into this market because they own half of it and they are a monopoly with that half. Now, I understand Apple's retort to that. Apple is like, every other market does this. The video game market, matter of fact, Epic Games has the same type of agreement and paying the same type of prices with PlayStation on the PlayStation platform, right? Not even on a cell phone, right? Hell, they're giving Google 30%. So, if it wasn't us, it was going to be somebody, and guess what they charge it? Well, we charge it, right? So there's no real harm here to Epic Games, right? Because they're getting charged what everybody else is getting charged. So I think this is going to be interesting because now it's going to push to see when you become too big, where it's 50% or a little bit over 50% of a market share of the cell phone industry. Is that enough to say that they have such control that they are a monopoly in that particular market? Or do you expand the market to what Apple's looking at? I think both are. It really depends on how the judge takes it. I think it'll be a hell of an appeal to whoever loses. But this is not Apple's only problem though. Because guess what? Soon as they file this lawsuit, the Justice Department is looking into it, and they got the lawsuit in the EU that they got to deal with. And guess what they're saying?
Australia too.
Yeah, and they're saying the same thing Epic Games is saying here.
Yeah.
So even if Apple loses, even if Apple wins here, they still losing every place else. So it's a lot bigger than I think we think it is.
Yeah. So I actually have a little bit of difference of opinion from you guys on this one. I remember I did a few videos on this case and the case against Google, sort of analyzing the issues. And I see based on the precedent that there is a possibility here. I mean, that the case really comes down to how you define the market, which obviously is a very complicated thing. This is not like a simple defamation case or a murder case or something where you can really just kind of look at, these are facts X, Y, Z, and this is how it applies to the law. This is like, I mean, you're kind of looking at macroeconomics in a way, because you're looking at you have to first define what the market even is in the first place. That's like the biggest battle, the first battle, and really the biggest one. And so really what it's going to come down to is that definition, because as soon as they decide how big or small that market is, they're going to figure out whether Apple is the entire market or whether Apple is a smaller piece of that market. And I think that one of the things that I found is really interesting is the ways the two sides are trying to sort of either broaden or narrow the scope of what that market is. So Epic Games is saying this is all apps on the iOS on the Apple iOS market, right? Whereas Apple is saying, well, it's not really that. It's not just apps. I mean, it's really just gaming apps. And then gaming apps obviously are part of like this other sort of secondary market, which you can also get games on consoles, on PC, et cetera, et cetera. And so if you look at it from that perspective, then it's like, well, I mean, iOS, app games are really just a portion of this overall gaming market. But if you look at it the way that Apple is framing it, it's like, I mean, this is not just gaming apps, but it's also educational apps. It's also, health apps, like meditation apps, and like all kinds of like stuff like that. So then it's like, Epic Games is a much smaller piece in this pool that's defined pretty much by Apple's market. So I find it to be really, really interesting. And I think that, I don't know. I mean, it's going to be a really interesting case. I personally think Epic Games has a fighting chance here.
Yeah, I agree that I think they do. They're going to trial, so I think there is a chance.
Yeah.
But I think the argument that I think Epic Games has to deal with is that the games that they produce for the App Store are produced virtually the same game on all these other platforms, right? It's on Google, on Nintendo, right? That's what Apple kind of said. I think Apple's argument of it's like movies. I can watch a movie on a TV or my computer or my smartphone. But if but nobody's going to say iOS got a, you can't, if I can't watch my movie, I think they had a market on the movie, right? Because we're talking about the median of use and the median of use product. Now, I do understand. I think Epic's argument is very compelling that cell phones or smartphones have a different type of use value to the consumer, right? We all use it, and it's a different. Now it's a different animal. It's like the car. Before we all had one, it was kind of it wasn't as important. And the AT&T argument, right, with even phones, before everybody needed them in everyday life, it wasn't a monopoly. So I understand Epic's argument, but I think the two big hurdles they have is just Apple's market share is just 50%. So really, we're talking about 50% of the market share, and the fact that those same games are used on multiple platforms. So to narrow the market to cell phones, you got to just have a really, really, really good excuse why that limitation. And I think the excuse they're putting forward that cell phones are unique is just not good enough to put it in the context of antitrust, especially if you can play the same game on your laptop and avoid the problem in the first place. But Uncivil, maybe you disagree with that.
Yeah, even if you think that the smartphone market is unique, Apple has the point that they might be 50% of the market in the U.S., but worldwide they're a lagger. They have a minority of the market. Android has been the dominant worldwide, and there's no reason to expect necessarily that Apple will always be the big dog in the room. They have competitors, and Apple also has a really good argument of one of the reasons they have 50% success is specifically because they're a walled garden. They have a look and feel that they curate. So they're kind of like Disney World in that respect. People like Disney World or don't, but they have a very distinct look and feel. I don't think anyone can deny that. Walt Disney World is very, very, very serious about its look and feel. So, and one of the reasons people like it is because of that. So it's a little bit like saying, well, you have this wonderful captive audience at Walt Disney World, which you do, because people are coming into your parks. We want to, it has to be only your food provider. It has to be only your entertainment providers. It has to be only your things. And we want to also come in. That's not fair because you have that controlled space. And one of the things Walt Disney would say, or Apple would say, is one of the reasons we have the success we do is specifically because we so well control our experience. And people like that experience. So if we allowed you in, it would ruin the experience. And people wouldn't like it anymore. It would devalue the very thing that you think is valuable. So I think there's a fair point to that. I think there's a fair point to be said that if Apple did or was forced to allow other app stores, the app stores wouldn't be as good. The apps that are on them wouldn't be as well reviewed or well controlled. People would have bad experiences with them, and that some of that blame would go onto Apple. Why can't you make a better smartphone, Apple? Well, we had a great smartphone until people ruined it. So I don't think you're wrong, Alita, and I don't think you're wrong, Nate, that Epic has some good arguments. There is this idea of sui generis, that the phone is different or special in some way, and so the analysis should be different. I'm not sure that since the Antitrust Act was written in the dinosaur age, it's the first special thing that's ever come along that is no longer special. I think there have been other special things that are no longer special, including the car, for that matter, that you alluded to earlier. So I'm not convinced that the Antitrust Act is a good vehicle for this mechanism. So probably the best answer I have at this point is it's probably more for Congress to fix if they want to, or maybe the EU or the Australians. But I'm not sure the remedy is in U.S. law. But, I'm willing to be convinced differently. As the evidence develops and as the opinions develop, I'm willing to take another look at it. So we'll see how it develops, I guess.
Yeah. Yeah, I mean, so I don't know though, because I think one of the reasons why I think they have a pretty good chance here is because of the fact that the analysis for defining the market is determined by just how you can kind of think of it as like how sticky is this market, right? What are the transaction costs for the consumer? And I really think that Epic has some good arguments there. I really think that that how they've said that. What did they said? That basically, in order to in order to be in this market in the first place, you have to have bought a device first. And for a lot of people, that's like a really substantial investment. And I think that truth has gone up in recent years, right? It's become
$1,000 for a phone.
It's become, yeah. I mean, it's you're buying a computer essentially. And so to say that you can compare that to buying a console for another $500 or $600 or $700, depending on if you're trying to buy a PS5 in today's day and age, and trying to buy it secondhand from somebody who's poached it from online, because it's impossible to get one. I know, I've been on this massive crusade with my husband. We're trying to check pretty much daily at this point to see if we can get a PS5 somewhere. So just as a little bit of background, I'm not a huge gamer, but my husband really is. So I've learned so much just through my relationship with him. And so I'm kind of like a secondary gamer in a way, like a backseat gamer, as someone call it. I basically tell him what to do. I'm like, throw a Molotov cocktail. You got it. Get that zombie. But anyway, so to say that it is, relatively easy for a consumer to switch from a mobile device, from one mobile device to another mobile device, where you've got other switching costs. Like I saw the other day that one of the things that came out in evidence recently, as like just stuff that's sort of been thrown out there by the parties out to the public, is an internal conversation by Apple about iMessage, and how that was something that they were considering sharing with Android, but they were like, no, we want that to be something that's a real source for keeping people here, is so that they can use iMessage. And that actually, I mean, I've seen that in real life, where I'm in a friend group and one person randomly gets a Samsung and we're like, what the heck? Now we can't use iMessage.
You don't have the blue icon, man. You're not cool.
Well, yeah, but also there's other there's other data benefits to that, right? Because iMessage is actually more encrypted than SMS. It's not the most secure, but it's more encrypted. And so there are certain benefits that come along with that. And so, I mean, I can see, so I can see their arguments for those switching costs for the consumer, and how that sort of creates this definition of the market according to Epic Games' definition. But I mean, Apple does have some good points that they have too, when they're talking about how, well, the whole purpose of creating this walled garden is for security reasons. That's so that they can rebut these claims of monopolization, et cetera. So that, because even if Epic does prove that Apple has been unlawfully monopolizing, which, by the way, just for clarification for people, it's not illegal for a company to be a monopoly. It's not illegal at all, not by a long shot. In fact, the Supreme Court has even said in some cases that, in some cases, it's actually a good thing to have monopolies, because that means that we have people that are innovating, they're developing, and they're creating new markets. So it's only when you're trying to maintain that through unlawful means that is therefore illegal. So, but even if Epic Games does prove that Apple is in fact monopolizing, if Apple has some really good reasons for it, and they prove with evidence that the security of the App Store, of the iPhones, etc., if that's a good enough reason and it's backed up by their evidence, then Epic Games is still going to lose.
Yeah,
anyway.
I agree with the point that Epic does have. I think they obviously have an argument, but I'm just thinking about it's really about compelling Apple to allow Epic Games to violate the terms of service, because that's what we're talking about here, right? Epic Games is saying we want to violate the terms of service by allowing more or less this pop-up to come after you've installed the game that says, don't buy from Apple, buy from our website to save them the 30%. That's essentially what they're asking for here. And there's also a part of this where you do have the right to refuse business to somebody, right? And Epic Games did contract into this agreement, but they can't. You can't contract into. You can't have a contract that's illegal. So if we're just talking about just purely on the fact of this, if this is a monopoly, or Apple is a monopoly in this particular space, I just see just a lot of hurdles for Epic Games. It's just really, really because it's the game, multiple platforms, even in the cell phone market. Even if I was just to link it to the cell phone market, because Epic Games is really trying to link it just to iOS. But I wouldn't even give them that. I would say let's talk about that because they're really talking about the cell phone market. I think even in the cell phone market, it's going to be hard to make it's going to be hard to make the point that Apple in the cell phone market, where they only really just have 50% share in the United States, as a monopoly, when you had that Microsoft, for instance, and you have other Facebook, for instance, who have larger market shares in their own space, who aren't, who the Justice Department to call it, but they haven't been deemed monopolies. So it's just going to be very difficult to just point to market share and the fact that they have this buy-in service, because everything that it seems that Epic Games was talking about when it comes to Apple seems just like good business practices, right? I want to get if you want to use this particular product only offered on my service, then yeah, I want you and your friends. And just like the one person who gets an Android, that's the punishment for buying an Android. You know what I'm saying? Yeah. Because we have a better product. Like I don't see that as trying to. There's a difference between trying to put somebody else out of business and trying to make your business more attractive. And I think any business has that problem, especially when you get into a larger market share. But the fact that there are companies out there with larger market shares in their particular space, and they're not deemed monopolies, Facebook, all these other ones with 80, 90%. It's and like you said, is this an illegal? I just don't see anything illegal here that Apple is doing that's convinced me that they even have a monopoly and they're keeping it by illegal means. But again, I have to first see the evidence, whatever they induce a trial. My mind can be changed instantly.
Sounds right.
Me and Kurt think alike. I think Alita's frozen.
She's frozen. Well, what do you want to talk about, Nate?
We're taking over.
Yeah,
Why chromosome night?
That's right. That's right. Why chromosome only? That's right. Wow. Oh man,
John O'Brien.
Did you see that Facebook advisory board decision thing that they released this morning about why banning Trump was good?
Oh, Alita's back.
Sorry about that.
Okay, yay.
Whew. Oh my gosh, that was horrible. Sorry about that. Anyway, you guys were saying.
We weren't. We were just talking about other things until we came back.
Yeah. But go ahead. So what's next on the list?
So next on the list is let's talk about Derek Chauvin. He's back in the news. We've got a motion for a mistrial, as was of course expected, and kind of for the reasons that we were all expecting as well. Although I looked at the motion itself, and I can share that here. Let's see here if it'll show up. Is it? Oh,
you should share that at the bottom.
Oh, it's because when it kicked me off, it took out my. Sorry, give me just 1 second here.
You're having a boomer moment. You're one of us. You're one of us.
All right, this is it here. Here we go. Okay, right. So all right. So State of Minnesota, County of Hennepin. This is the defendant's notice of motions and post-verdict motions. So basically the argument is, pretty much the reasons that we all expected, that that there was, there was publicity ahead of trial, the jury wasn't sequestered, and et cetera, et cetera. The court abuses discretion in making all of these decisions. So this, I don't think it refers to the news that came out recently about the juror that apparently was attending George Floyd protests over the summer, and then subsequently became a member of the jury, supposedly.
All right, do this, Aaliyah. Control F, right, and type in jury. Jury misconduct.
Jury misconduct.
There it is. It's right there. It's one time. He mentions it one time, but it seems like he fails to actually object to it in the bottom.
That's
interesting.
Like you mentioned it in the caption, we're going to talk about juror misconduct because that's what we were talking about. But he forgot to mention it, and one of the fans they pointed it out. I was like, "Oh, damn, he didn't object to it. Fail. He didn't put it in the motion."
Might want to revise that one while you still got time.
Yeah,
it's there now.
Yeah,
no, it's not.
It kind of is. just not the
A vague
allegations.
illusion whisper is not really what's going on. In fact, I read at least one court of appeals case that said this explicitly, where I think it was in the context of a footnote, but merely putting something in a perfunctory footnote or something like that is not enough to preserve the issue. You actually have to do more. So I don't think this caption is going to do the trick.
Yeah, that's true. Oh, that's rough. That's really rough.
Especially with a some stupid lawyer like me catches it, and now he's like, nah, you forgot to put. It was probably one of the letters they probably forgot to put in, and it's like, oh my god.
If you want to revise that, give it another shot.
Yeah,
and it's funny because I thought like you. I was like, oh, they just probably did this before. But then the fact that they had jury misconduct up there, I was like, they forgot to put the damn thing in there.
Yeah. So basically, but just in case people are not aware, there was apparently there was news that came out recently that apparently a juror had attended George Floyd protests. I saw a photo of him, or an alleged photo of him. I want to be fair to everyone, depending on whatever reporting is going on. An alleged photo of him wearing.
He says it's him now. He says it's
okay.
It's his uncle. Yeah, he admits.
Okay, that's fair.
It looks very suspiciously like him.
Could be a twin. Who knows? So wearing a T-shirt that has MLK Jr. on it, and writing around it that says "Get your knee off my neck," which sounds a little bit like someone's made a decision already as to what happened to George Floyd. So the allegation is that he was very politically motivated, and that he got himself on the jury by lying about his impartiality. But if that's not reflected in the motion, that's rough.
That never happened.
This never happened, right? Never happened.
Yeah.
Well,
I already know what the Court of Appeals will say. I can write the decision in my head. Well, that makes it real easy. It's like I was going to have to actually worry about standards of jury misconduct and stuff. Now it's a real easy legal decision.
Yeah.
You forgot to put it in your brief. Yeah.
Yeah.
Because it's notice stuff. So.
Yeah, that's true. That's the notice of motions, and then here's the actual motions. But it's
talk about jury misconduct in there.
No, he refers to it, but this is all about how the court abuses discretion.
We always said if it's not raised, it's waived.
Yes,
and this is definitely not raised. It says it. He alludes to it, but
and that's the thing is that so with any kind of appeal, you have to have had an objection that was raised timely, meaning you can't have waited too long, obviously. So I'm wondering though, when did the news about that juror come out? Was that on the 4th or the 3rd? When was that?
Something like that.
It was before this motion came out, though.
Oh, was it? Okay.
Yeah. And then why would he put jury misconduct in there?
Yeah.
And not mention it without the whole motion.
Unless this was like an earlier draft that had been written that they were like, I'm sure there's jury misconduct.
That's a legal fail.
That's always a possibility. But my other thought was like, if this was prepared before that actually came out, then maybe they could file another motion. I don't know, but
I think the judge might let him file a correction if it was a oversight of the wrong draft kind of thing.
Yeah, and most times most of the times you get to amend one time by the way.
Yeah.
Right? So this is guess what? You forgot. You talked about it. If he notices,
you forgot the major point, the essential point of the argument.
Yeah. Your biggest tool in your tool shed.
Also, for example, the law as it relates to this in Minnesota specifically, which I don't know. So I don't know if you know the law in New York as a former prosecutor. I would assume you have way more knowledge than me. So let's assume this is a New York case, and you have this. So as memory serves, the juror on the jury questionnaire, when he asked if he had heard about the trial or George Floyd, said something along the lines of, I hadn't heard much. I only heard some stuff dealing with court dates.
But you know what
he had to say.
To be honest with you,
it was a little bit more than that, one would suspect.
Yeah, I've never actually had to deal with this issue.
Yeah.
But I would say this. It really is going to come down to the technicalities, to the nuance of all this stuff, right?
Yeah.
Because it always, as lawyers, bad questions get bad answers, and if you get bad answers, it's on you. It's not on the person answering the question. So here you got 2 questions and you got 2 answers. The first question is, did you ever attend any protests within Minneapolis? He answered no,
which is true.
True. The second one is, have you ever attended any protests about police use of force? Right, very general, very open. He said no. So that's the question that we're talking about now.
Yeah.
Now that's the question.
The rally in question was it strictly for? Wasn't it?
Well,
for
the rally, the place. Yes, he was going. Every year they have the March on Washington anniversary. So this was the 57th anniversary.
So him saying no would be a truthful answer to that question, the way it's phrased.
It was a truthful answer, but there's some more nuance here. The theme of that year's event was police, police violence and police use of force, right? It was announced multiple times, even at George Floyd's family spoke, even at George Floyd's funeral. We're going to do the March on Washington. It's going to be against police violence. So him answering that question properly would have been, it could have easily been either one, yes or no. If he said yes, that would have been factual. If he said no, it would have been factual. So now, is that just happens to be a bad question, or was it a bad answer? And if the answer yes or no is good for that question in this particular instance, I don't know if I can say that was his answer was bad. I just think the question may have been poor. What do you guys
Even
think?
if his answer is bad, though, I'm not sure it's enough in and of itself, because they had an opportunity to orally voir dire the jurors, and I believe, although I could be mistaken, the counsel at least knew the names of the potential jurors, I believe, and so had the opportunity to vet them through their own social media, whatever, and there are companies that will do that for you. So it might be, even if he answered the question wrong, you had an opportunity to discover that information, you had an opportunity to ask those questions, and you didn't use it, so you lose it. So maybe sucks to be you is the right answer to that one too. But I don't know the law enough of it strikes me, although it strikes me unless you tell me something specific. If I had to guess, it strikes me unlikely that this would be enough to overthrow the entire jury.
Oh, you're muted.
Am I?
No, Nate is. Sorry.
Oh,
no,
okay.
I was saying generally you're right. This would definitely not be enough on its own. But obviously he's putting together a cumulative package. I don't know if you guys want to just go over the various points. But the cumulative package here is what matters. So it's just not 1 or 2 points. It's the entire thing. And that's what I think the lawyer is doing well here. But by leaving out this big one, you start strong and end strong. I start with what he got here, and I would end with that. And then at the thing, after a long read like that, then you have something here. But now I think that alone is not enough. It's part.
All right. So what else do we have in this thing? Abuse of discretion for failure to sequester the jury, right?
Yes.
Yes.
Okay. Well, that's not going to fly because sequestering the jury comes with its own negative downsides.
Right. And then also for changing
balanced.
the venue. So he requested to change the venue, and then
that's not going to fly because changing venue is a disfavored remedy, strongly disfavored, and the usual remedy is more voir dire, which they gave them. So.
And one thing, but it's one thing about changing venue too. It wouldn't have solved the problem, because the reason why you change venue is to get a jury who doesn't really know about the story. But here, where else are you going to send it, right? Who hasn't heard the George Floyd story? I even said it this morning. If you don't know the name George Floyd and Derek Chauvin, welcome back from your coma.
And you can bet if they had changed venue to some random town in Minnesota, one would imagine the sudden increase of press at that courthouse would have drawn some attention to this story. So
that's true. Yeah.
I'm not sure how much it would have changed in the end.
Right.
So we're going to pick this random small courthouse in the middle of nowhere. Well, it's about to become TV Central, so there's that.
Yeah. I mean, I was going to say probably the only people that hadn't really heard about it were the guys that were on the SpaceX flight or shuttle that went to the International Space Station like 3 days before. And then, but even then, like they're back by now, right? So they can't be on the jury.
Right.
But yeah. So
maybe we can get some Minnesoters who are living abroad somewhere and call them back.
Even
Paris or whatever.
Even abroad, there were protests. There were George Floyd protests around the world.
All across the world.
Oh yeah.
Yeah. So I mean, it's hard. It's hard to really find a jury that truly, where people really didn't hear about it. I mean, I guess that, the one thing that I can really think about is maybe, looking at Minneapolis, how people are like, this is our home and this is our police department that, we may or may not be angry about, we may or may not support, just based on our own personal experiences and how it relates to what we see as our survival. I mean, I could maybe see it, from that perspective, as opposed to someone who just kind of has an opinion on something because they've heard about it and they've, seen stuff on the news, or people that are like, no, this is happening outside my front door. I don't know. I mean, that's the only thing that I can think of, just sort of looking at it from the other perspective. But I don't know if that's a good enough really distinction. I think that no matter what, there was going to be this issue for Derek Chauvin.
Yeah, if this wasn't a press case, if this wasn't a big case, then I think changing the venue. If it's local media, right? If local media only covered it, then changing a venue is a good thing, right? Because most of the time, that's people outside that local area is not going to hear about it. But I don't think the remedy here, changing a venue, would have changed. It's because that's what you're talking about, right? These things are supposed to be so outrageous that they could have changed the outcome of the trial, and I don't think changing a venue would have done that. What's B say?
What's that? Oh, B.
No, what does B say?
Oh, B is, the court abused its discretion when it denied defendant's motion for a new trial on the grounds that publicity during the proceedings threatened the fairness of trial. Such publicity included post-testimony, but pre-deliberation intimidation of the defense's expert witnesses, from which the jury was not insulated. Not only did such acts escalate the potential for prejudice in these proceedings, they may result in a far-reaching chilling effect on defendant's ability to procure expert witness, specifically in high-profile cases such as those of Mr. Chauvin's co-defendants to testify on their behalf. The publicity here.
I'm sorry. That's asking for a remedy for someone else. Like, just because these experts may not want to testify at these other trials, that has nothing to do with this here, right?
Right.
Why would you overturn this verdict because it may hurt someone else? It just doesn't make sense.
Yeah, just because they might in some other trial get some sort of like people will give them a hard time for being an expert witness. I mean, people are going to give them a hard time regardless of what the court decides on this issue. Defendants are probably going to get, or witnesses for the defendants are probably going to get a hard time from people because of their testimony.
Yeah.
So yeah, I don't know about that one. And then so C says the court abused its discretion when it failed to sequester the jury for the duration of the trial, or in the least admonish them to avoid all media, which resulted in jury. Yeah, that's what I thought.
Yeah, he did that. Yeah. But again, this is a kitchen sink approach. Just throw everything you can and see what sticks on the wall.
Yeah. So, and then which resulted in jury exposure to prejudicial publicity regarding the trial during the. Yeah, I mean that was that seemed to be pretty clear. Was that the judge said several times throughout trial? He's like, we've told the jury that they can't look at the news. They can't
watch anything about the trial.
Yeah, exactly. And so I don't know. I mean,
but the problem here is that. He's trying to have like a backdoor way into kind of saying that, in terms of, instead of, because generally you'd have to show an offer of proof that a juror watched the news or do something. You can't, you can't just make this allegation. So this is just kind of throwing it out there in emotion, just like, hey, the juror was affected, but there's really no factual basis. Maybe he does, maybe, and because this is just a notice, maybe in the actual brief he's going to have, here's my evidence or here's my factual reasons for making these allegations. Because right now I just don't see it.
Yeah. Oh, and then he talks about prejudicial prosecutorial misconduct.
That I remember
because of the stuff that he did during the closing and sort of belittling the case.
Yeah,
it didn't strike me as enough personally. With the belittling, I've seen some cases where that are pretty atrocious and sort of belittling and demeaning the defense, but I don't know if it was enough.
Overturn a jury verdict for that?
Yeah.
I don't think so. Yeah. But again, we're looking at it individually now, but we're also looking at it cumulatively.
Of course.
End, so.
Right. So I mean, like if you've got a whole list of reasons that are all kind of like kind of maybe, does that do a bunch of kind of maybes add up to something that's actually gonna do it?
It's possible, but I don't think these are good enough.
Mm-hmm. Yeah. let's see. And then it says the court abuses discretion and violated Mr. Chauvin's rights under the confrontation clause when it failed to order Maurice Hall to testify or in the alternative to admit into evidence Mr. Hall's statements to law enforcement regarding his interactions with George Floyd and presence at the May 25th, 2020 incident.
But that he'd forget the guy got a Fifth Amendment right. To just,
yeah, but if he
keep
made
his mouth
statements
shut,
to the
right?
police, that's arguably statement against interest.
Yeah. Yeah.
So there's something there.
Statement against they went over the statement against interest. They did go over the statement against interest for the guy, but
They did? Okay.
yeah, they did. But the problem was that the state has a right to cross-examine that witness. So but then you have witness unavailability. So can you?
Yeah.
Because the
witness unavailability, yeah, no, it should get you where you want to be, at least under the federal rules.
It's interesting.
Yeah.
Because Maurice Hall it's really a Fifth Amendment claim, right? It's against self-incrimination. So,
yeah.
Yeah, interesting.
Yeah.
Should they have let those statements in? I don't know.
Under the federal rules, I think. I'm not sure about Minnesota specific rules on the hearsay, but on the federal rules, I would think so. Yeah.
So
Fifth
Amendment,
it's a statement against interest.
because we're talking about hearsay. This is hearsay we're talking about.
Yeah.
A statement against interest.
Yeah.
I mean, their rules maybe I don't know. They
Should we go look up the
they may be
Minnesota
funky.
specific rules of evidence? Ooh,
Forgive me. I'm just thinking because
I'm
each
down.
side,
I'm a lawyer. It's
because-
fine. We
because
can geek out on it.
no, because you my thing is that by allowing that testimony in, you don't allow in a cross-examination of that testimony, right? About how you feel, this there's a lot more doing, even if you have the agent come in and testify to it, really the testimony is going to be the person making the statements. So
Yeah.
just for instance, in generally these hearsay statements wouldn't be allowed to come in against the defendant, right? Because the defendant has the right to cross-examine and confront the witnesses. So
Right.
you can't just let unless you have the deathbed confession or something that the defendant then it
But
kind
the
of
defendant wants it in this case.
Yeah, that's
So
what I'm
the
saying.
defendant's
But then
constitutional
the
interests
state,
aren't being affected.
but the state then has a right to cross-examine
They
those
don't have a
witnesses.
constitutional interest in it. Whatever
Yes, they
interest
do.
might have.
They
In
and plus-
cross-examination, a
Of
constitutional
course,
interest?
you're talking about the state.
No.
The state has, of course, the state. The defense can't just put witnesses up there, and the state has no.
I'm
right
not saying that
right
they
to
can. I'm just saying
cross-examine
they
them.
don't have a constitutional interest in it.
I don't know. I think there is a due. I think I can make the.
The Constitution doesn't extend rights to the government.
No,
Yeah, I
I
mean,
disagree.
Well,
The government. Well, obviously. Well, go ahead. Go ahead.
I mean, I would agree that it's probably not a constitutional right, but I mean, it would be under the rules of evidence.
Yeah,
Right?
that's
Yeah,
true.
well,
yeah, I'm just saying. But the
I'm
thing
saying
is,
it's a due process right. I'm saying it's a due process right in terms of. But I agree with the informant comes in obviously with the rules of evidence. But I just don't understand. I just think even with the fundamental fairness, if the defense is able to put someone on the stand, the state has a right to cross-examine them. But again, it may
They
not
should be able to. Yeah.
yeah, but there might be a lot of reasons why this witness is not available to testify. Like the witness is dead. Or,
Yeah.
Whatever.
That's why I'd have to look at those exceptions again.
Yeah.
That's
Yeah.
fair.
All right. So this is a bar exam question at this point, guys. So
No,
go
it's
do your own
fascinating.
homework.
Oh yeah,
We'll have to reconvene.
I'm
Do some
I'm-
research
I'm-
and come back.
I'm probably totally wrong even on that issue, but I think this is a good issue because it even got us thinking about it.
Yeah, for sure. So, if we're talking about deposition testimony, now that I'm thinking about it, usually, I mean, in a deposition, there is an opportunity for the other side to do a cross-examination during the deposition.
Sure.
So I've seen that before where deposition testimony was brought in because the witness had died, and there was a cross-examination by the other side at deposition, and so that was pretty much the only opportunity that they had for a cross-examination. They read that into the record along with the main testimony. So yeah, I mean, yeah, if they were if he was not going if there was a proper deposition that was taken in this case, I hadn't heard about this issue actually
Right now,
before
I have
this.
to Google Minnesota rules of evidence. Huh?
Now we're there.
No, it's actually there, right? He actually puts he just cites the Sixth Amendment for the confrontation clause.
All
But we're
right,
actually
let's
talking about
see.
Maurice Falls.
Hearsay. Cite utterance, mental condition, statement, mental diagnosis, or core recollection.
You're talking
No.
about unavailable witness.
I know that. I'm just looking through all of them.
Oh.
Records readily conducted, absence of entering records, public record, vitality, absence of public record, family record, records, documents, interest, statement in ancient documents. I wish. Reputations, no. Okay, so let's try 802.
I think it's an 803. Hearsay exceptions.
Unless it's like the federal rules in which they put in 802 for reasons that pass everyone's understanding.
Oh, that's true. Yeah, I don't know why they do that.
If you send me the link, I can throw it up on the shared screen.
Oh yeah, I'll just put it in the StreamYard's private chat.
Okay.
There's
Sounds
801 at
good.
least.
All right. Let's see.
802.
And let's get this in here. While we are, there we go. Okay. 801, evidence, definitions. Statement, hearsay. Statements which are not hearsay.
It's not a party opponent.
Prior statement by a witness. The declarant testifies at the trial or hearing and is subject to cross-examination
We don't got
concerning
that.
the
Not
statement.
subject. We don't have that. It wasn't subject to cross-examination.
Yeah.
It's 804. Go to 804.
Okay, how about 801 D2? Statement by party opponent for exception E. Statement by co-conspirator. So the idea would be that the drug dealer is a co-conspirator in the conspiracy to distribute drugs, right? So it's a statement of a co-conspirator in the crime of dealing drugs.
But that
So we
crime,
can get
that's not a crime that's
being
actually
charged,
alleged in
yeah.
this case.
There's no crime. That's not a crime in the case.
Yeah.
He's not even charged with that.
They made it very clear
It doesn't say it has to be charged in the case. It just says a statement by a co-conspirator of the party.
Well, what's the conspiracy though?
It says that there must be a showing by preponderance there was a conspiracy involving both declarant and the party. The statement was made in the course and furtherance of the conspiracy. It doesn't say that the conspiracy has to be charged.
But I think, in order to have a co-conspirator, you have to have determined that there was a conspiracy, and that's not something that they were even looking at in this case.
Well, Floyd will get you halfway, or apologize. Yeah, okay.
Yeah, because you have to have the agreement, overt act. I don't see any of that here. But go to 804.
All right, you're right. You're right. It was an idea. I retract.
click the next link. 804.
Yeah,
it's for unavailable
I've got that
witnesses.
up. Yeah, evidence, hearsay exceptions, declarant unavailable. So when
now it gives you the
when a
reasons
witness
why
is-
they should be.
Yeah,
Yeah.
exempted one. Exempted by ground of privilege. And that'll be that. So there you go.
Yeah.
Following or not excluded. Former testimony, statement upon belief and pending, statement against interest. Statement which at the time of making is so far contrary to declarant's pecuniary propriety interest.
Yeah, I don't
A
even
reasonable
think you got
person would
that.
not have made the statement unless believing it to be true. Works for me. I'm sold.
Yeah.
Yeah, that's the one I think you can try to use, but I don't think
804B3.
Yeah.
804B3.
B3, statement against interest, right here. Oh,
Yeah,
if it'll let me. There we go.
but I don't know because the statements that he made, I don't know if they even qualify statements against interest. They would open
Against
him up
his
to criminal
interest?
liability because he was saying stuff like, he's give a fake name, said he didn't know that, like his statements weren't something like I killed the guy, and then it's like the hearsay exception. That's what I'm thinking of, statements against interest or something that's and that way, not just any statement against interest. You know what
But
I mean?
if that, I don't know though, because I was under the impression that a statement against interest includes any kind of a statement that could give rise to liability or criminal liability.
Yeah, that would be a proprietary interest as far as I'm concerned.
Yeah, and in this case, I believe that's there. So I think, yeah, I would say that
It
this
says so in
would
the last
count.
sentence, actually.
A statement
Statement intending exposed to prevent criminal liability
yes.
and offering criminal case is not admissible unless corroborating clearly indicates trustworthiness.
Yeah,
Yeah.
so
It's not sufficient
actually it's not.
corroboration? Oh,
Yeah, so it's not. So
okay.
a statement 10.
So the exception to the exception to the exception might be kicking us in the teeth now.
All right.
Oh boy. So okay.
You see how much fun it is to be a lawyer?
Yeah, I
this
know.
is- so this
Let's
is the
go another level
exception.
deep. Let's
Yeah.
go
An
inception.
exception to the exception. Yeah.
Suddenly we're all sideways on the wall.
That's right.
It's often how I feel in the law. But okay, so interesting. So that's that particular issue. Now that I think we've dug into that, I mean, okay, well, we'll see what the court says, right? I feel like that's always a good way to end these.
The question usually, at least on appeal, would be if it had been admitted, would it change the result?
Yes.
That's usually the question for some sort of clear error or reversible error. It's like, not only did someone do a bad, if that bad hadn't happened, it would change the outcome.
Yeah.
Because as I mentioned before, we had the stage of proof until proof innocent until proven guilty. That was what I was looking for. We had the innocent until proven guilty phase. That has happened now. So now we're in the guilty until proven otherwise phase of the exercise. So we sort of flip everything, and now we're interpreting the reality in light of the guilty verdict, which has now happened and been entered onto the record. So now we're not trying to say, well, we're not in the same position of saying, do we have proof beyond a reasonable doubt anymore? That's over now. We're in the position of saying, if it hadn't happened, would the result have changed?
Yeah.
And no.
And also in sentencing, well, again, this is the motion for the post-trial motions. But even in sentencing, things like hearsay and stuff can come in too, and propensity evidence can actually be used during sentencing.
Oh, so sure.
The game has changed a lot in sentencing. A lot of people don't realize that.
Oh yeah, you can use all kinds of stuff against the defendant now you couldn't use before. Prior bad acts, propensity, hearsay that you couldn't probably use before.
Yeah,
all kinds of crap.
It's funny because you can't only use hearsay during the trial. You can use it actually even in a grand jury stage.
Oh,
You
yeah.
can use it after trial, but during the trial, you can't use hearsay. So.
Yeah. So okay. So moving on then. The court abuses discretion when it submitted instructions to the jury that failed to accurately reflect the law with respect to second-degree unintentional murder, third-degree murder, and authorized use of force. Was that the case here, though? I thought.
But even if that's true, that's a mistake of law.
Yeah.
So,
Yeah, that would be.
That's something the Court of Appeals can figure out, which will overturn the third-degree murder statute.
Yeah,
but
which I think, this is where he would have to make that argument in order to, right? Wouldn't he need to in order to preserve this issue for appeal?
I don't know, because he made it earlier with it being re-entered in the first place, which might be sufficient. I don't know if he necessarily has to make it again, but either way, sure, why not? But why not?
Yeah, I think I at least that would be good practice anyway. At the very least, even if it's not required, it would be considered good practice because no attorney ever wants to end up losing on
Where's
something
the
like
one
that.
dealing with unduly cumulative witnesses, unduly repetitive witnesses?
That's here too. I'm pretty sure. Let me see.
Which hopefully they'll go into some more detail. Cumulative evidence with respect to use of force.
Mm-hmm.
It was the next one. You should just let us read the next one.
No, the cumulative effect of multiple errors, that's different than what I was saying. I was talking about the cumulative evidence because the idea would be that too many witnesses for the prosecution to testify.
Type in use of force. It's under
we just saw that.
There it is. Yeah.
So here, cumulative evidence. Which
I was a little bit surprised that the judge let as many people testify for the prosecution as they did.
So I agree. It definitely. But usually the reason, at least this is always how I've thought of cumulative. The objection for cumulative evidence is that, it's more of an issue for the efficiency of trial and the judicial economy, right? More than anything, that was my impression.
But also too, it's a rule that protects the little guy from the state. Because the state can run 100 experts, they can pay for them all to come in and say, yes, this was wrong, and the defendant can only pay for one. So the cumulative effect just makes it so, it's just, Joy doesn't say, well, there's so many doctors on that side, and so I think that's kind of what you had here a little bit, because they only had one ME and one use of force expert because of resources where the government has 5, and how many cops? 10 cops. So
yeah,
the
that's
unduly cumulative is probably the best shot that he has because how many did the prosecution have? Was it like 42 something?
Something, but like ridiculous high.
It was a ridiculous number. How many people do we need how many people do we need testifying about use of force? How many people do we need testifying on medical stuff? It was a lot.
I think but the medical, and the reason why, think about this, the reason why he just,
they're better off on the medical stuff because each one has a specialty.
He didn't go for the medical. He went for the use of force.
Yeah.
Okay.
The reason why he didn't go for the medical is because, like you're saying, each one had their own specialty, but then their own doctor didn't say Floyd didn't die of. He just said it's inconclusive. So even if you say it was cumulative, it really wouldn't change the outcome because the doctor didn't say the opposite. He just kind of said he didn't know. Right. I think with use of force, though, you had all these people, like 10 people, saying this use of force was wrong. That's what made it cumulative.
Yeah. Okay. That makes sense. That makes a lot of sense. Okay. Well, so there's that. Any other thoughts on that point?
Nope.
No, it just seems cumulative.
Yeah.
That's what he's doing in his motion, to give us a cumulative motion.
Any more comments on that would just be cumulative. So then they said that the court abused its discretion in violation of Mr. Chauvin's constitutional rights and due process and a fair trial when it ordered the state to lead witnesses on direct examination.
Fair. Now, the reason they did that was to attempt to prevent the witnesses from going off script, or at least the idea was to keep them closer on script and to prevent them from going into domains other than where they were supposed to. That was the idea. It was also a little bit weird because the defense wasn't allowed to lead on its direct, which if you're going to offer the remedy of the state gets to lead on its direct, shouldn't the defense be allowed to also lead on its direct just out of fundamental fairness?
Yeah.
But for some reason, no.
For clarification, which witnesses are we talking about here?
I think we're talking about the prosecution.
We're talking about the prosecution witnesses. Sometimes they led them, but I want to ask you guys this one question, and this is when the lawyers get sneaky. What constitutional right is he talking about?
What
constitutional right is he talking about?
Right to a fair trial, basically.
It's like it's about this. He's just saying the due process and fair trial, but he doesn't point to a section like before. It was the Fifth Amendment, the Fourth Amendment. He just is due process, right? It's just.
Due process isn't a bad place to start.
I think this is it's almost like just a throwaway, almost. I don't know. I understand the argument, but he's not really specific enough on what he's challenging with due process, because I don't know what you'd point to say that this is, maybe if there's still like the court violated its own rules in allowing, because in the federal rules of evidence, for instance, it specifically states there that you can't, on direct, you cannot use leading questions.
Right.
But I'm not sure if that's also true in Minnesota.
Right.
Yeah, but it's a rule, right? And usually rules can be suspended if they need to be.
Yeah, but I'm saying, all right, if it's not the same, if they don't have this rule in Minnesota, then he doesn't have a right. You understand that the federal rules, it's not unconstitutional to have direct. Sure. It's actually against the federal rules of evidence, right? The federal rules of evidence says you can't do it. It's not against the constitutional right. Go ahead. I'm sorry, Alita.
So I was just about to say. So, however, we are going to be using. We were looking up the Minnesota state rules of evidence, but we are in federal court. No, we're not.
No, we're not.
No, we're not. You're right. Okay, you're right. Okay, I was still on like Epic Games versus Apple. We're not in federal court. Okay, I was going to say we are under the federal rules of evidence, but we're not. So. Okay.
What jurisdiction are we in again? Yes, right.
Minnesota.
No, I know. It happens to me too sometimes. It's fun.
I know. Yeah.
Somebody's throwing out 403B. Don't bring up 403B in the chat.
But the other thing that I was going to say is that anytime that we're talking about a fair trial, we're talking about the Sixth Amendment. So I think it's I mean, or at least you can reasonably lead that to the Sixth Amendment, because that's where that comes from. So, I mean, if they're referring to the fact that he was deprived of a fair trial, I mean, you can reasonably say like, okay, that's, we pretty much know where that comes from. So.
Yeah, no, well, I'd agree, but again, if state law allows you to have, because state law could be more, could be more liberal and could allow.
I don't think it does because they didn't
they
didn't allow the defense to do it.
No, I'm not saying it does. I'm just saying there may not be a rule. It may just be a common law thing, where the judge has a little bit more discretion over it. But again, in the federal rules, it's actually in the statute. When some states, they don't have them in statute. They have them in the common law principles.
Well, to quote Barbosa, they're not so much rules as a set of guidelines, because courts have amazing discretion over their courtroom. So,
Parlay.
Yeah, exactly.
Well, I'll say this: if we were in federal court, he'd be citing that particular rule, right? So that's it. Yeah. So.
But federal judges have egos 5 times bigger than anyone else's, so they're like, it's not nice and all. But here's what we're doing now.
Oh man. So okay. So then I guess was that the last one? No.
This is why I should be a federal judge, because I have the ego for it. I'm already there. Let's go.
Yeah, you just need to be approved by Congress.
Yeah, I just need to trick the Senate into thinking that I'm a good judge.
Okay, so
you got any friends, Alita?
I have a few.
There you go.
I have obviously you two, and
all right, there you go.
And I have others as well. Of course. So let's see. So the court abuses discretion in violation of Mr. Chauvin's constitutional rights to due process and a fair trial when it failed to order that a record be made of the numerous sidebars that occurred during the trial. That's interesting.
Really? That doesn't seem right. There wasn't a record kept of those, really?
Yeah, it's weird for me too when they said that, because it's like, I don't know that they didn't. I don't know. That's weird.
That is, yeah. I would have assumed that would have been kept as a record, and I want to hear more about this.
But there are some sidebars that are off the record. Like when I was in criminal court, sometimes you would go to sidebar and it was off the record, but then sometimes you'd have sidebars when that were on the record, right? So I don't know. It all depends on the particular sidebar, what it was for. If it was for a point of law where you're making an objection, it's usually on the record. If it's sometimes they'll say off the record and they'll bring you over here, blah blah blah. And we'll have a little conversation. So I don't know.
Yeah, this one's interesting. I'm curious to hear more about it. I mean, this is just one sentence here, so that would be interesting to hear more on.
I am dubious concerning this one sentence.
Yeah.
Hey, here I'm gonna give you a link. Somebody give us a link to Minnesota Rule 611 about cross examinations. They want to put us into hell with this thing. So,
thank you, John O'Brien.
Yes, John. John's probably a lawyer.
Thanks, John.
In hiding. John. But here's the link. And I think its leading questions should not be used on direct examination of a witness, except as may be necessary to develop the witness's testimony. So it's not allowed, but it is allowed.
Well, that's true in federal law too, because if you have these like prefatory, you can do questions like, "You were there that night, right? Please describe what happened." So you can do a prefatory question like that.
But this is actually a poor. But why not cite this rule then? That's a poorly drafted motion. He's citing rules on some of the places, but not citing this simple rule of evidence.
Well, there was a motion about this issue. It's not like it popped out of nowhere. There was a motion concerning this. Yeah, the idea at least was they wanted the witnesses to not stray into domains that were restricted by motions in limine. So the idea at least was we're going to use leading questions on direct to hopefully constrain the answers of the witnesses, was the theory. Which, I guess, I don't know. I would think that could be dealt with the witness prep, but then again, the state had 3,000 witnesses, so that's a lot of witnesses to prep.
That is a lot. Yeah. Well,
now we know our answer. So
yes,
again, the judge will determine it.
Yeah.
And then another judge will determine it, and then maybe some other judges will determine it, depending on where this goes.
Yeah. Who knows?
And what John is saying is correct. It seems just to be discretionary on leading, so you really have to show discretion. So that's a pretty high standard too. So
yeah, it does. It is. So this is not a situation where there are obviously if people don't know, there are different standards of review for for an appellate court, there are different standards for various motions. So what we're talking about here is an abuse of discretion by the judge. So basically, any other court reviewing the decisions of this judge has to determine that despite the leeway that he had, despite the discretion that he had, he abused that in order to make this decision. And so that's a bit of a higher standard than just saying.
That's a tough trigger to pull.
Yeah, it's harder than if they were reviewing it de novo, which is
plain error.
Exactly.
Yeah.
So this is interesting. So have we beaten this horse enough?
Oh yeah, it's dead.
Okay.
For the moment.
So, all right. So you guys have time for one more story?
Yeah, but do you guys think this is going to be successful or not? Well, obviously they're going to add the juror piece in here. Do you think? What do you think the chances are of this before we get out of here?
Unless I learn something in a brief at some point, my thought is very unlikely, except for the third degree, which I think is certain.
You're gonna die on that horse, aren't you?
I'm pretty convinced I'm right, so we'll see.
Yeah, I would generally agree that I think that there's not enough here that I've seen that's like, ooh, this is the smoking gun that's gonna really get it for them. But
yeah, I think it's a shot, and as a lawyer, he needs to take his shot. But I don't think it's a great shot. I think you tell the Lord, get ready for the long haul. If because it doesn't look like we got a chance here, but we'll make it happen.
Get ready for the next 25 years. Sounds about right.
Yeah.
We'll see if I'm right on that ×2 multiplier. Sounds about right to my mind.
I like this. This comment.
What did it say?
More necroequinosadism, as in beating a dead horse.
Yeah.
Anyway, okay. So one more story. I think will be good. So this organization, Black Hammer Organization, I came across this earlier this week because I was on Twitter and I saw that, I don't know if you guys saw this, but I saw that Anne Frank was trending, which usually is not a good thing. It's usually not for happy reasons. Yeah. But I guess apparently when I kind of looked into it, because I was of course curious, looked into it and I saw that I guess the reason why she was trending was because this group has apparently in the past said, and I guess recently reinforced, that they are of the opinion that Anne Frank is a colonist. They have, I guess, a particular definition of what a colonist is. It sounds like it is all non-people of color. And I was kind of curious looking into this organization and what they're all about. And it looks like they have a particular goal. I don't know if they have other goals as well, but one goal that they have is that they are trying to take land back for all colonized people worldwide. They're focused on building dual contending power of and for the colonized masses. So what they've done recently is they have bought land in Colorado, and they are aiming to build what they call Hammer City.
Okay.
Hammer City is Black Hammer Organization's latest project, building a city for all people of color to be free, no discrimination of nationality, gender, age, mental, physical differences, etc. They are for jobs, housing, food, and healthcare. They say that they will have no cops, no rent, no coronavirus, which is kind of not necessarily up to them necessarily, and no white people, which could be up to them possibly. They are for returning the land to indigenous people and building the first Hammer City in Colorado. So my first thought on this is that legal? Can they build a city and say we are going to exclude all white people from this city? Obviously, there's a whole culture war sort of aspect to this, but I kind of want to focus in on the legal side. Kurt, why do you say that?
I'm hard pressed to think of how you could do that. First of all, because of all the wonderful fair housing law on the federal end would pop into play. So Fair Housing Act would pop into play. If you were going to what are you going to do? Try to put restrictive covenants that you can't sell to people of certain races? Well, we tried that one. That was illegal, so that's not going to fly. If you have a private entity that is running an entire city, well, we're sounding suspiciously close to company town territory at that point.
Yep.
So I'm thinking that is an issue. So I'm not seeing this working for a whole number of reasons.
Yeah. Yep. Agreed.
Yep.
Agreed.
I definitely agree. I only have a quibble with one thing you said was that covenants, racial covenants, are illegal, and I think they're unenforceable. They're not illegal.
Well, what's the difference?
Well, because unenforceable means you can actually write a racially restricted covenant, but you can't enforce it by taking it to court, because that was that ruling that you said. They said it was legal, but it was unenforceable. So essentially you have a contract that can't be enforced by the courts.
Yeah, I don't know if maybe you're giving me a hard time on the word illegal here, but let me rephrase. Contracts have to be authorized by the relevant law. You can't have a contract for an illegal thing. Contracts for illegal things are void, and the government gets to change what is legal and illegal. So a contract that restricts someone from selling based on race is invalid as a matter of contract law. So how about that? Is that better?
Only reason why I said that is because I got that question wrong on my Tesla time.
Really?
And I was like, you have to be effing kidding me. Yes, my contract says. It was like,
It's
no, the
not
contract
illegal.
is not.
It's unenforceable.
The contract is unenforceable. Yes, illegal contracts are also unenforceable.
Yeah.
Right? An illegal contract, a contract for sex, for instance, for money, that's an illegal contract. That's unenforceable.
It's a contract for an illegal thing. Yeah.
Yes, but a discriminatory contract is actually now, obviously, with Fair Housing Act and all that stuff, it's illegal. But in the universe, but back then in that particular case, it wasn't illegal.
So are you saying is the idea that it's not illegal
was,
because it's some version of unconscionable and that's different? Is that what we're going with?
Well, it was unenforceable because of the 14th Amendment, right? That's the reason why it was unenforceable. So you're right. I think technically I would say it's illegal, but I
got marked off on an essay question.
I got
Alita, are you buying this on an essay question? There's a difference between illegal and unenforceable, or am I just howling at the moon here?
No, there are some contracts that are illegal, therefore unenforceable, but there are some contracts that are legal and unenforceable. So that's the distinction that was being made between legal contracts that are unenforceable and illegal contracts that are unenforceable.
Yeah. Yeah.
Okay.
I mean, I would say, however, I mean, if we're thinking from a layman's perspective, that is a bit more of an academic distinction, I think.
Oh yeah, definitely.
Yeah.
It's so academic that I'm not 100% sure I know what we're talking about, and that's sad.
Yeah. So one of my first thoughts on this one was the idea, because I'm pretty sure that I haven't looked too deeply, but I think that this that this group is holding this land as a corporation. So I'm pretty sure that this is starting to get into Marsh v. Alabama territory, which of course was the First Amendment, and in this case, it looks like we're looking at what, the 14th.
Yeah.
So because we're talking about
this is Marsh v. Alabama.
It is Marsh v. Alabama. Yeah.
Yeah, because we're talking about racial discrimination, which I know that in many circles these days, racial discrimination, people have tended to define that as only as including this power dynamic. Under the law, that's not the case. For racial discrimination, there is no requirement that you prove that the person being discriminated against has a lack of power in some respect.
Yeah. Also, just out of raw curiosity, how exactly are they going to be defining person of color?
That's another question.
I mean, seriously, are we into an 1/8 rule or a 1 drop of blood rule?
Right.
Because that worked out super duper well in the South.
Well,
so
hold on, but
how are we planning on defining this exactly?
I agree.
There are a couple of questions here. Number one.
What?
Right.
This is my first question.
Yes. Well, it's because I like to try to think about these things in a purely legal manner.
Right.
Uh-huh.
And in trying to evaluate this, there are a couple of things, because obviously we're talking about private, and for just people in the chat, if this is a private company, private entities, private people, the restrictions of racism and things that the government has to adhere to, a private person doesn't, right? I can say, I don't want any white people in my house. No offense, guys, but I can say that, and I can be legally within my rights.
And you're not even subject to the Fair Housing Act. I think Fair Housing Act doesn't kick in unless you own more than 4 homes.
Like 4 homes.
So hey, you go nuts.
So that's where we're at. But in this particular instance, if you have something that, because it's the duck test, right? Sewers, things, police, all that stuff. If it looks like a town, it walks like a town, it cracks like a town, it's a town. So
It's a town.
And so what happens is the March v. Alabama kicks in, where you now have to give those rights to anyone else, right? You can't discriminate. So right now, I would say Hammer City, as a legal matter, would have to adhere to the constitutional constraints because of the way it's being described here. Because that's a town. I don't think there's any way you can get around it.
Right, because it looks like they're contemplating not just a house or one person's piece of land, but they're contemplating an entire society existing on this land.
Yeah.
With
now,
many properties.
If one
managed
person
by a
owns it all,
corporation, which wants to discriminate on the basis of race.
Let's say it's just one person who owns all the land. Then I think we have a different analysis.
No, you're still screwed, because if you have more than 4 individual properties, you're still in the Fair Housing Act.
No, you have to be renting them out though to people. So you don't have, as long as you rent them out.
All right. So what is your hypothetical here? We got a really, really rich person who owns the entire neighborhood and all the houses, and he's just giving them away to people.
The Bush
sure.
Ranch 40
yeah,
acres,
he's going to
right?
do. Okay, maybe. I'm sure I can find something that he's doing that's illegal or at least unenforceable if there's a difference.
No, I'm saying, but in contrast, one person maybe not the best thing, but here. It's just I don't see how you can discriminate here. I just don't see it.
Yeah, unless
almost impossible.
So you could have one person that is owning the land if they're holding it out for a commercial purpose. I mean, like think about like Disneyland, for example, can't discriminate.
That's true.
Yeah,
but that's under state law too, and you'd have to look at state law here too.
Right.
No,
that's true.
That's very federal too. That's how they broke up all the hotels.
That's
part
right.
of Atlanta Motel.
Yes,
versus
that's right.
Whatever.
Because that was part of interstate commerce.
That's
but
right.
Which
we could quibble with that decision if we want to irritate everybody.
But Disney's an amusement park. I know the hotel. The hotels is one thing, but amusement parks you think would fall under commerce?
Yeah,
I mean, because they're being held for people to travel from out of state.
No, maybe.
To come there for. I mean, if they're advertising out of the state, then
because the interstate commerce clause, the reason why hotels was covered up in it is because people need hotels to travel between states, right? So so open roadways, travel venues, those type of things. So that's what gave them the interstate commerce clause. But I don't know if
isn't Walt Disney World in Florida also legally a town, or am I having a
it might be
minor?
It might be.
I think it does.
But they have hotels there though. But they do have hotels, so I think so they would be covered under the Fair Housing Act because you can stay at Disney World. So, but but under the Commerce Clause. But it's still I don't know, just any generic theme park. I don't know.
I think so. I think it would. I mean, obviously, it would be a very fact dependent analysis. But I think if they're advertising their park out of the state and they're trying to get people from out of that state to come there.
Yeah.
That kind of advertising is they're subjecting themselves to interstate commerce.
I think we can take official notice that Walt Disney World is advertising out of state.
Yeah. But advertising out of state,
out of the country.
Yeah.
You're intergalactically probably at this point.
Yeah, Disney's everywhere. Interesting legal question, but yeah, Hammer City, they definitely have to follow the Constitution.
So first of all, this is super racist.
Okay.
Second of all, I almost want them to be able to do it with the no police thing because I'd love to see how that's going to work.
Yeah.
How are you anticipating no police? Is this going to be like the Chaz Chop thing, which was super hilarious? I love that so much. It's like we're kicking out all the police, but we're going to have people. We're going to build a wall, and we're going to have people monitoring the boundary to make sure people don't come in.
Yeah.
Kind of like a border patrol, and we're going to have people walking around to make sure no one is supposed to be who isn't here.
Yeah.
It sounds suspiciously like police. And that one video, which I love so very, very much, where that one woman said, is there any strong white men here who can help, basically control these people? Which sounds suspiciously like you're asking for police. So yeah, it's like, let's abolish the police and then let's immediately create the police.
Yeah.
So yeah. I'd love to see this no police thing. Let's see how that works. That'd be great. No jails, no courts. This should go real well.
Yeah, I mean, it definitely. I would be curious to see if they have a particular definition of what they mean by by no cops, no police, if they mean just no police that are put in place by the government, or they want their own private militia, I don't know.
Oh yeah, that's good. Yeah, we have our private militia. That's hey, that sounds good.
This is like the Branch Davidian comp. This is just like any of those crazy compounds that people create. We're all going to be free, love, and everything until the cops start breaking it up. So
now I will say that. So from looking at the their who we are kind of page, it looks like they tend to be all very young people. They look like they have a particular sort of utopian idea of what they want to set up. I mean, it'll be interesting to see if they've bought land. It'll be interesting to see if they even manage to, because it's a huge project to try to build an entire city, right? And who knows? I mean, maybe they will. Maybe they'll.
But his legal counsel approved this.
No, but even though
what lawyers did they hire to draft this thing up?
500,000 goal. That's a pretty light goal too. Because don't forget, you're also talking about liability for people getting hurt and taking care of people. It's God bless them. Hopefully they can make it. What can I say?
Yeah. I mean, yeah, right. I mean, yeah. Let's see if what happens. So, but any other thoughts on that one?
I almost want to see it happen just to watch it all blow up.
Yeah,
it's like, we'll keep a wall around. Yeah, we'll build a wall around you. Not so much to keep you inside. As
we'll help you with the wall.
Inside. Let us know how it works out. If anyone's alive tomorrow, we'll ask you how it worked out.
I actually hate saying this. It's like they want to combat discrimination with more discrimination. It just doesn't make any sense to me.
No, you don't say. They would have.
It's like we're against racism, so what we're gonna do is no white people. It's like, what? Huh? What the hell are we doing here? Like, isn't that what we're against? No, well,
one drop of blood, man. What? One drop of blood. Who's this now? Is it David Duke again? I get so confused.
This is it's insane. It's insane.
Yeah, it's strange. It's definitely strange for sure. So, well, on that note, I guess we can probably close out this stream. But as always, it was wonderful having my friends here with me. And next week, it looks like we'll be on Nate the Lawyer's channel for more fun legal talk.
Well, next week we're on Uncivil Law's channel, aren't we?
No, we were on my channel last week. It's your turn.
You know what? I have it all in my calendar. And my calendar said this week, but I forgot we switched to 3 instead of 2, so I'm probably just.
I know, because I snuck in, and I screwed everything up.
You missed the end of the thing. You missed the end of the thing, though, Nate.
Oh, that's really the one. Yeah.
You missed something special there with the looks of confusion and bewilderment.
It's funny because the end of that. When I was rewatching the stream a little bit, and going through the comments and stuff, I was reminded of. So I have an uncle who has a propensity for funny T-shirts, and he loves giving those for like Christmas gifts and stuff like that. And he had so I remember he gave me a T-shirt because I really appreciated one that he had, and he gave me a similar one, and it said either dazzle them with brilliance or baffle them with bullshit. And I felt like that was a very appropriate T-shirt to pull out and look at.
I'm assuming this was the rebuttal.
Yes.
For the plaintiff, but she had a shit case anyway. We all know her case was shit.
Yeah, but it was bad, Nate.
It was that bad.
It was really bad.
It went from a very reasonable argument and legal explanation to. I mean, just literal incomprehensible word vomit. I mean, it was just like, I don't know. I don't know how many breaths she took in those few minutes in between sentences. So
Would you put it on the resume? Would you put it on your resume, or would you be embarrassed to put it in your resume?
That particular
rebuttal?
That I argued it for the Supreme Court, and here's the link.
Don't look it up.
I mean, at least in her case, apparently she's a very experienced attorney arguing before the Supreme Court. She's got apparently a pretty good win-loss record in front of the Supreme Court, but this was not one of her shining moments, I guess. So, and I don't want to disparage the, another esteemed member of the bar, but
well, they do a shit job. They do a shit job. It's all right.
Yeah. So anyway,
I like it. Like we're so the honorable soldiers here.
Well, we do like to stand for the profession and represent it well.
That's true.
That is true.
Tell that to Brown.
The profession, each other.
Tell that to Brown and Salty. Those are the two that need
Brown needed some help. I hear there might be settling, though. That's the rumor now. There's on Twitter. They said they might be settling, which is so disappointing. We might not get part 2. I'm sad.
And for everyone watching, in case they're unfamiliar, which case are you talking about?
This is the Toddy Westbrook, Katie Joy Paulson fight, which basically turned into the attorney fighting. So it was supposed to be Toddy Westbrook versus Katie Joy Paulson, but it turned into Michael Brown versus Michael Saltz. And we kind of forgot Toddy existed for a while because of how much the attorneys were fighting each other. It was something to behold. The shade and the things that were being said against each other. Listen, it was an interesting experience.
Listen, that was like a $200,000 case that came down to 5 sheets of paper. You're in the wrong goddamn court. Boom.
Yeah, the whole thing got tossed on personal jurisdiction, but the way that we got there was very entertaining.
Basically, I mean, you can a pretty good metaphor for that is like when in Dark Knight, right? That was the one with the Joker. Yeah. When he has a massive pile of cash and he's just like, I'm just gonna light this on fire. And that's cool. I'm happy with that. Yeah. That's basically what happened in that case.
Yes. So I said I'm going to miss that case too. Oh my God! Well, I'm going to miss that case. I'm going to miss it. Yeah. But we called it though. Me and Kirk called it stone cold. We said jurisdiction is an issue. People laughed at us. They said we're not even attorneys. They said Kirk is just sitting in the couch. Nate is not an attorney. They don't know what they're talking about. Then afterwards, what do we hear? Well, these guys know what they're talking about.
Amazing.
Yeah.
I particularly like the part in the opinion where they said Lorianne was irrelevant, and I egoed out after a while because I was like, I told you guys.
There were so many videos of everybody keeps saying, well, uncivil law called it. She was irrelevant, and you guys said she was irrelevant. Then you watch the next video. Uncivil law called it. He said that she was irrelevant. I was like, this guy's getting all the fame now because he said those stupid words. Lorianne is irrelevant. That's it. Every now commentator. Uncivil law. So
people began to recognize my brilliance. It's about time. That's what I would say.
And she was irrelevant. Burnt $100,000 burnt in 4 lines. Boom. Oh, Lorianne's irrelevant. Lawyer spent 20 hours on the phone with her. It's like crazy.
Poor Lorianne. She's this random witness sort of, and she got dragged into this thing. Oh and my God. It was kind of unfair to Lorianne. I felt bad for her at many points.
Well, she burnt a lot of their money though.
She did burn a lot of money.
She did like 50 hours with the first lawyer, then she flipped sides and did 50 hours with 2 lawyers in 3 days. It was like some.
But apparently they agreed to stay the statute of limitations while they're conducting their negotiations.
I told you the statute of limitations was an issue because we're coming up to May, and that was the first thing. It was a year. Yeah. So.
I didn't know at the time, but I looked it up later that the dismissal for jurisdiction does not stay. So yeah, you go back to the original. I didn't know. I had to look it up. But yeah, you were right. It doesn't. If you lose on the personal jurisdiction, you're done if the statute lapses. So yeah, so they're agreeing to negotiate. So I'm not sure over what, but I guess Toddy was tired of the drama and it taking so long. She thought maybe it'd be quicker or something. And she doesn't want to go through it again. So maybe Katie will win in the end, and we'll never get to see the settlement. That's very sad.
Well, Katie's got to be burnt out of money. She's got to, come on. How much was that? Got to be burnt out.
Well, Katie at least said on her channel that when we kept saying $100,000, she says, "Well, I don't know where they came up with that figure. It's not anywhere close to that. We're doing the math in our head based on the hourly rates they're quoting." Yeah, and we're like, I don't know, man. It seems.
Yeah.
Seems there were 3,000. Well, not literally, but there were. How many documents were filed in that case? Was it 48?
It was something crazy. Yeah, it was something.
It was 48 documents. 48 docket entries just on personal jurisdiction. There was the complaint, there was the motion to dismiss, there was the response, and then there were 5 different precipes with responses. There was a motion to disqualify. A motion. No, wait. It wasn't actually a motion to disqualify. It was a motion
to qualify.
It was a motion for me to remain qualified.
Yeah,
it's the strangest motion I ever saw in my life.
So
I am
preemptively
asking the court to tell me that I'm not disqualified.
But so people understand the Tucker Carlson case, which went all the way through, right? With like
it went to conclusion. It was done 35.
Yeah, it was something like 35. This one we didn't even get to argue universal jurisdiction. We're like 48. It was like we're at 1A. We're at 1A
with exhibits. So many exhibits.
Oh my God!
And declarations from everybody.
And that's the kind of case that for me is, when I've been practicing litigation, it's the kind of case that makes you want to pull your hair out, because you're just like, what are we even doing here? We're not even resolving a case, because at the same time, you probably also have other cases that you're working on at the same time that are maybe moving way faster. It's just, as a professional, it's just so frustrating to be in that kind of a case where you feel like you're just stuck in the mud. And it's just, oh God, just to get to what, a motion to dismiss 42. I mean, that is insanity.
It was pretty bad. Go watch my playlist sometime if you're really, really bored and have like 30 hours of your life you don't want to get back.
Hey, what are you doing this week, Alita? You got anything coming up?
So this week I'm gonna probably dig into the Epic versus Apple sort of updates at trial a little bit more, and sort of see if I can come up with some good thoughts on it. How about you guys?
I'm probably got like 2 videos coming out this week. Just the problem with me is just that my videos just take so long, because I try to the PowerPoints and the editing and all that stuff. So I'm trying to. It takes about a week for me to do a video. So I don't know, try to get it out.
Yeah, when it comes to pre-recorded videos, it definitely takes a while to edit and get things right. I've noticed that too. I've been able to sort of decrease the time that I spend on it, in comparison to however many months ago when I started. But I mean, yeah, it takes a while. It takes a lot longer than obviously a live stream.
Have you guys ever had that? Like, there's been parts of the video where I'll leave a part in, and I'll be like, that was a mistake, or I'm like, why did I leave that stupid thing in? And that's the part that everybody loves. It's like, I was like, what? That was like there's one time, I forgot what my last video. There's like a stupid part in there. I told my wife, I forgot to cut that out. And the next thing I know, I'm looking in the comment section. I love when you said this. I love when you said this. I'm like, all right. So it's like they love the mistakes. So
yeah, that's true. That's true too. So, but yeah, you've been doing a lot of not cancer, but like fraud cases, right?
Yeah, I got a full confession from somebody on the other day on my channel. So yeah, so you can watch it start from. It's a fake cancer thing. So yeah,
good Lord.
And the woman, she said she wanted to talk, so we talked, and she gave it up.
Oh my!
And that's a sad thing too. I was like, she confessed to forging documents and fake fundraisers. So I'm like,
Mount Chesson. So that's fun. Yeah, that's good times.
Yeah. Don't confess to me online if you're doing crimes, right?
Yeah, because then that becomes evidence potentially. That's
yeah. Well, faking cancer is pretty scumbag.
It's pretty bad.
Yeah, it's pretty bad. It's pretty bad.
And it's like the second one I found out of this group. One with the guy faked moving. The other one stole $10,000. This one fake cancer, stole $5,000. So it's crazy.
Oh man, crazy world we live in. How about you, Kurt?
Well, now I'm thinking about faking cancer because apparently that's the way to move forward in my life.
Oh, no. Oh, no.
No, obviously not. No, I've got a whole bunch of stories in the queue. So I just try to look and see what's going to be good at any given time. So let's see what looks like it's coming up in the queue that might be positive.
Yeah.
We got so much interesting stuff. We got one dealing with an asylum case that was denied. One dealing with cell phones and they're being searched at the border. Solitary confinement that was really abusive. The cops not being happy that their information is now subject to FOIL, which is New York's version of FOIA. So that's your former brother and Nate. They're not happy. They tried to sue about that. So yeah, we got a whole bunch of stuff that we got coming up. Maybe I'll do CDC and them being shut down because it turns out the CDC tried to say we can prevent people from being evicted, and no. So maybe I'll do that tomorrow. That sounds fun.
Yeah, that's another interesting development that just came out. So yeah, interesting stuff, good stuff. So and then for me, so other than Epic Games versus Apple, so I did a live stream on Monday with Phantom Lord, also known as James Varga, the Twitch streamer who was kicked off of Twitch and then sued Twitch for breach of contract and then won. And so we did a live stream where he and his attorney talked to me about the whole lawsuit and the experience and kind of a lot of the issues and whatnot. So I will be releasing some cut clips from that to sort of give some more digestible pieces, because otherwise that was like another like hour and a half long stream. So, yep. So that's that.
Cool.
Cool. So, anywho, yeah. So I guess that's about it, and we can I guess sign off. So thank you guys. Thanks for the conversation, and thanks to everyone watching and commenting. This has been wonderful. Okay. Until next time, guys. See ya.